A battery of the country's top legal minds representing parties involved in the 7 consolidated petitions appeared before the Apex Court, the Chief Justice Martha Koome leads. The second petitioner in the presidential petition against President-elect William Ruto's victory, John Njoroge, through his lawyer, General Banu Joe Mohammed, has requested that IEBC chairperson Wafula Chebukati be prohibited from conducting any election or holding any public office for breaching the Chapter 6 of the Constitution.
We have requested that the chairperson be prohibited from conducting any further elections in view of his behavior and or holding any public office in Kenya in breach of Chapter 6 of the Constitution of Kenya. The reason why we've said that is, unfortunately, whilst we created independent offices, we forgot about Chapter 6. And I think this court needs to show the way, even if it's to the lower courts or subordinate courts, show them the way that it's Chapter 6 that is going to be a question of integrity.
John Mohammed told the court that it is in his interest that millions of Kenyans who casted their votes to know if indeed their votes counted in the presidential results declared by Independent Election Boundaries Commission Chairman Wafula Chebukati.
Was this accurate? Was this verifiable? It's our humble submission. The commissioners who came out, the disconnect between the commissioners shows that there is a problem. Mr. Chebukati says it is verifiable and accurate. The voter, what does Mr. John Njoroge know? The commissioners are saying it was opaque. Where does the voter go? Has everybody forgotten the voter in all of this? The political parties are saying, I won, I won. We want to know what happened to our vote. And where we are today, we actually cannot say that where this vote went and what happened.
According to lawyer Paul Nyamodi, IEBC chairperson Wafula Chebukati planned from the onset to single-handedly run the August 9 general elections. In his submissions, Nyamodi told the court that Chebukati gazetted himself as the national returning officer and assumed the roles of the 290 constituency returning officers who are mandated to conduct elections.
Such a gazette notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday. You cannot be taken to have been done that with the best of intentions.
Lawyer Njiru Ndegwa, who is representing petitioner David Ngari, faulted Chebukati for blatantly refusing to declare the results in the remaining 27 constituencies, saying it was an obligatory requirement in Article 138, Chapter 4 of the Constitution. The counsel, in his defense, told the Supreme Court that 27 constituencies left out were indeed the strongholds of Azimio la Umoja One Kenya Raila Odinga, which created room for mischief.
He has glossed over that weighty issue. He does not consider that 27 constituencies, which makes about 10% of the Kenyan constituencies, which translates to about 1.9 elected voters, were not included in the final tally. And what does he do? He makes and he amends and carefully uses the words which to apply. In his replying affidavit, he technically avoids the use of the word declaration and he uses the word announcement. The word announcement is not akin, is not similar, and does not mean declaration.
The Busia Senator-elect activist Okiya Omutata was forced to use PowerPoint presentation to prove that neither Raila Odinga nor William Ruto attained the 50% plus one threshold required for one to be declared president-elect. Omutata told the court that Independent Election Boundaries Commission IEBC KIMS kept transmitting election results a day after the elections had ended, dumping 508,647 ghost votes that carried William Ruto past 50% plus one mark.
The KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why a KIMS kit would still be transmitting 23 hours after
the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper.
There were light moments in the Supreme Court when lawyer Willis Otieno belted out nursery rhymes of Piki Piki Ponki just to drive a point home.
It could have been William Ruto, it could have been Raila Odinga. It fell on William Ruto and he says, voila, you are the president. Is that how we intend to choose our national executive? We've reduced it to Mimi's childhood game of Piki Piki Ponki.
Council again.
Yes,
He was making submissions on behalf of Khalifa, one of the petitioners in the consolidated case seeking to nullify the victory handed to President-elect William Ruto following the August 9 presidential election.
In the violation of the Elections Act itself, because, my Lord, there was a requirement that once the tallying is done and the verification done under Article 138 3C, it was not the chairman but the commission that was required to undertake that process.
President-elect William Ruto will have a chance to defend his August 9 presidential victory on Thursday. The Independent Electoral and Boundaries Commission IEBC Chairperson Wafula Chebukati and the commission will submit their defense. Chebukati and the commission will be represented by Senior Counsel and former Attorney General Githu Muigai, Eric Gumbo and Kamau Karuri. Davis Mberia, Ebru News.